the record should reflect Mr. Ross is present here in the courtroom. This is the date and time set for sentencing in this matter. Mr. Ross, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
I have.
Mr. Seeger, are there any additions, deletions, or corrections?
Your Honor, there is one somewhat major addition, correction, or deletion, and I did discuss this with the prosecuting attorney. I did allude to it at the time that he had taken the plea. Because he's not eligible for 7411, the people would allow him to withdraw his plea. He's sentenced on a possession of narcotics as opposed to the possession of methamphetamine, which will change theoretically the guidelines, but the recommendation is not changed. So I would just ask the court to allow him to withdraw his plea, use his factual basis for the previous plea, and then enter a conviction relative to possession of narcotics as opposed to possession of methamphetamine. At which point he would still ask the court to go forward with sentencing today, which I had indicated to Department of Corrections and the prosecuting attorney.
Okay, and that would be a 4-year maximum.
Correct, Your Honor.
Okay, Mr. Ziegler.
If that's accurate, Your Honor, it's what we had discussed at the time. We were concerned about his eligibility. So I would support that this time.
Okay, Mr. Ross, have you had a chance to talk about this with Mr. Seeger?
Yes, I have.
Okay, and you understand that the difference would be rather than having the possession of methamphetamine, which is a 10-year felony, it would be a conviction to possession of narcotics, which is a 4-year felony.
Yes.
Is that how you wish to proceed today?
Yes.
Okay. So the court will order that Mr. Ross plea be to the possession of methamphetamine be withdrawn. The court will order that a conviction as to possession of narcotics be entered. The court will adopt Mr. Ross's testimony from the plea hearing as the factual basis for the change in the conviction and the acceptance of the plea to possession of narcotics. Mr. Ross, you understand that the report that I reviewed all relates to the possession of methamphetamine, and that includes the scoring of the guidelines. This would be a different charge, and so you would have the right to adjourn today's hearing, have a new pre-sentence report prepared reflecting this new charge, and then have the court sentence you based on that new information. Do you understand that?
Yes.
Obviously, all the other information remains the same, you know, the description of the offense, all your background information, none of that is going to change. What would change would be, you know, the guidelines and that type of thing. Did you still wish to proceed with sentencing today?
Yes.
Okay. Aside from what we've stated, Mr. Seeger, in terms of just the other factual information within the report, are there any additions, deletions?
There is nothing else that is different, Your Honor.
Do you know what the guidelines would be?
I don't, Your Honor. I guess to the extent that the court is going to follow the recommendation, I don't know as if it matters per se, and I don't even particularly care, Your Honor, if he's not going to be placed on probation because the recommendation is limited to court costs and fines because he's already on probation through Grand Traverse County. Somewhat of, I don't want to say it was an afterthought, Your Honor, but it wasn't really wholly contemplated other than to lower the grade of the sentence down so that later it's a lesser matter.
Well, let me ask this, Mr. Ziegler, the recommendation is for time served. Are you going to be asking for something different than that?
No, Your Honor. And I would also note that the possession of narcotics is a G-grade felony. I think the scoring is the same. So on the G grade, it would be a 0 to 9.
Okay.
Sentencing guidelines.
All right. Mr. Ziegler, do you have any changes to the information in the body of the report?
I do not.
Is there anything that you would like to say for allocution on behalf of the people?
Your Honor, given the recommendations, I think there's good reasons for the recommendation that existed at the time that PSI was prepared for the possession of meth. I think all those reasons are equally applicable to the lesser offense. So I would just ask the court to adopt the recommendations contained.
Thank you, Mr. Seeger.
And likewise, Your Honor, I would just ask the court to follow the recommendations. And speaking with Mr. Ross, you know, he went through a difficult time period in his life and he was struggling a lot and he was perhaps using drugs as a means to address his underlying problems, which he recognizes it's not a positive thing. He wants to go forward, make positive changes in his life. He wants to try and put this all behind him. He recognizes that this type of decision making is not beneficial to his life in general. But he generally strikes me as a good person. He just found himself in a bad way, with making bad decisions, and he finds himself here. But going forward, Your Honor, hopefully he doesn't have any further conflict from the justice system. This continues to be a learning lesson for him. Clearly, if he comes back again, the court will probably look at things differently. So be that as it may, Your Honor, he's just asking the court to follow the recommendation, but well knowing that this is probably his best stop in terms of getting a break, in terms of what may happen. Choices.
Thank you, Mr. Ross. Anything you wanted to say?
Just, I know I made some mistakes. I got an 8-year-old daughter. I haven't really seen her or talked to her since I've been incarcerated from 2 different counties. I know I need to get better, not just for her, but for myself, so that I can be better for her. I'm ready to do that, and I'm ready to do my probation and do it successfully. I haven't really ever done it before, so, but Travis got a lot of resources I plan on using, so hopefully I've worked my whole life, I've done commercial roofing for like 6-7 years. I've built houses for a few years, I got some skills and trades. And the last couple of years I really haven't worked or done anything, because like Mr. Seeger was saying, I was going through some hard times in my life, dealing with some stuff mentally. Wasn't handling it very well, so I just want to get back in the groove and get back to work and be there for my kid that I've always been there for, except for these last 8 months now. So just get back to my life, and make something of it, or take back some of what I used to have.
Like I said, I did read through the report, so I'm familiar with the circumstances of this case, as well as your background, your personal circumstances as well. I do think the recommendation is appropriate. I would say, getting clean is obviously something that you need to work on. A big part of that is people you're associating with. Just looking through the report, I recognize some of those names. They've been in front of me. Some of those guys are pretty heavily involved in drug trafficking, and you need to get yourself out of that world first of all, and associate with people who are doing productive legal things in their lives, and that's going to help you overall. If you want to get clean, that's going to be a big key to that. So I hope that's the way that you go forward, that you take advantage of what's available to you in Grand Traverse through your probation there, like you said, because all of those things are going to be important for you going forward. In terms of this particular case, given your involvement, given the circumstances, given that you are going to be under supervision still in Grand Traverse, I think the recommendation, again, as I said, adequately addresses your involvement here and punishment for that. The court is going to sentence you to 102 days in the Calcasieu County Jail with credit for 102 days served. The crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Seeger, if you can have Mr. Ross acknowledge the receipt of his appellate rights. Mr. Ross, these papers are going to explain to you how to file an appeal as well as how to request support.
Is that going to be like an added count 3? Okay, can I get the PAC code then for that?
333-7403-2 A as in Adam 5.
All right, thank you.
Ms. Wagner, I'm just going to request that you prepare an updated PSI with this new charge as the conviction, with scoring and guidelines, so that obviously the PSIs follow people, and so we need to have an accurate SIR.
Yeah, Shonda's already working on that right now, so those changes will all be updated. Do they need to be distributed to anybody?
I think just for me to sign the SIR.
Okay, yep, we'll get that to you.
Okay, thank you.
Thank you.
Okay, good luck to you going forward.
Thank you.
All right, let's talk about that. The sentencing hearing for People v. Clayton Ross offered a solid example of how a courtroom can strike a balance between accountability and second chances. Judge George Mertz once again presided, maintaining a professional, level-headed atmosphere while overseeing a procedural course correction and a thoughtful sentencing that didn't overlook the human side of the story. Mr. Ross was originally set to be sentenced for possession of methamphetamine, 10-year felony. But thanks to a joint understanding between his defense counsel, Mr. Seeger, and the prosecution, led by Mr. Siekler, the charge was amended to possession of narcotics, a 4-year felony. Why the change? Turns out Mr. Ross wasn't eligible for a deferred sentence under Michigan's 7,411 statute for the meth charge, but would be under the lesser offense. All parties agreed to the adjustment, and the judge allowed Ross to formally withdraw his original plea and accept the new one, using the prior factual basis on record. A bit of a procedural pivot, but it went smoothly with everyone clearly on the same page. Now, let's talk about the sentencing itself. This wasn't a case where the state sought jail time beyond what had already been served. Mr. Ross had banked 102 days in jail while the case moved through the system. Both sides supported the recommendation of time served and no probation from this court, largely because Mr. Ross is already under supervision for another offense in Grand Traverse County. In other words, this case was treated as a serious but secondary matter, not swept under the rug, but not escalated either. That said, the personal remarks are what really stood out here. Mr. Ross spoke honestly about a downward slide, losing contact with his 8-year-old daughter, stepping away from work, and struggling with mental health and addiction. He didn't dodge responsibility and even noted how badly he wanted to get back to his old self. It was a raw but composed moment that gave the judge more than just paperwork to consider. Judge Mertz responded in kind. He acknowledged the harm caused by Mr. Ross's decisions, but kept the tone constructive. He offered real advice: change your crowd, get out of that world. It wasn't preachy, just practical. The judge had clearly reviewed the pre-sentence report and recognized names tied to Mr. Ross who were, in his words, pretty heavily involved in drug trafficking. A subtle but important warning: stay clean, but more importantly, stay away from those pulling you down. The sentence matched the tone: 102 days in jail, with credit for the full amount already served, plus standard fines and fees. The hearing closed with administrative cleanup, updating the pre-sentence report to reflect the corrected charge so the record accurately follows Mr. Ross going forward. All in all, this was a measured hearing. The legal mechanics were handled cleanly, the tone was respectful, and the message to Mr. Ross was clear: you've gotten a break, but this is the edge of the road. Time to walk a different path. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.